Welcome back. Now, the Supreme Court has ordered the Electoral Commission to submit the full list of persons who registered with the National Health Insurance cards before June 29. The court also ordered the Commission to set out into writing steps and modalities it will use to ensure the full compliance of the judgment issued on May 5.
Former People's National Convention PNC National Youth Organizer Abu Ramadan and Evans Nemakon went back to court to seek clarification to the May 5 judgment, which, according to the plaintiff's interpretation, ordered the Electoral Commission to delete names of persons who registered with the NHIS card. In his submission, counsel for the plaintiffs Nana Asante Bedietu argued the orders of the Apex Court to the Electoral Commission were clear and could not have attracted a different interpretation from the Commission. He said persons who registered with the NHIS card do not belong to the voters register because they did not properly register as voters. The Chief Justice Georgina Wood, who chaired the 5-member panel, said the judgment gave out laid-down principles to clean up the register but did not state specifically the Commission must delete names of persons who registered with the NHIS cards without recourse to the Constitution. She further stated the judgment should be carried out without disenfranchising any voter who therefore required the EC to re-register affected people. The court sought to find out from the counsel for the Electoral Commission the procedure it is using to comply with the orders of the court by making sure the voters register is cleaned. Tatio Sori failed to spell out exactly what is being done to get the Electoral Commission to go to the polls with clean and credible electoral register. Georgina Mankwa and Sule Amadu, both deputy commissioners of the Electoral Commission who were present during proceedings in response to the question of the justices, said the commission is in the process of deleting names of multiple registrants and will also use the opportunity at the exhibition to clean the register. This did not go down well with the judges, who insisted the orders of the court supersedes any other thing, and the judgment should have been the first thing the commission should have considered. The Chief Justice urged the lawyers to seek the interests of the nation rather than their clients. The judges said they will not allow anyone to plunge the country into chaos and will make sure the right thing is done. Sitting resumes on June 30.
Let's do some legal analysis over this. Lawyer Yao Pong is a private legal practitioner and the lecturer at the Central University Faculty of Law. He's joining us. Good evening, sir. We're grateful that you could join us again. I know that earlier this evening we spoke extensively on this on 3FM, on our radio station. But let's now move further. Should the Electoral Commission fail to comply with this new directive of compiling the list of those who registered with NHIS cards and then going ahead to delete, what would that mean and what action can the Supreme Court take in the event that the EC fails to do this?
Well, thank you very much. In the first place, this matter started with the first Abu Ramadan case, and then the subsequent one. They were all in relation to interpretation and enforcement of the Constitution. So it means that any pursuant orders that are given must be complied with, and that those who are ordered to comply with fail or refuse to do so, then the necessary consequences are also spelled out under Article 2 of the Constitution, where a person refuses or fails to comply with any orders made by the Supreme Court pursuant to the interpretation or enforcement of the Constitution. If the person is a president or vice president, that can be a ground for his impeachment. And if the person is any other person, then he can suffer imprisonment for for at least 10 years. So that is what we have at the moment. And of course, we must be able to establish willful disobedience to the orders of the Supreme Court. And that itself becomes a different criminal proceedings, or appropriate proceedings will have to be commenced to establish that.
I know that you and I have had extensive conversation over the May 5th ruling, and I quite remember that we were discussing the ambiguity of that ruling, and you insisted clearly that there were no ambiguities, that if this was so, it is something that has been created for the convenience of the Electoral Commission. Does it surprise you that after the May 5 ruling, we've got to this point again where an individual, a citizen of Ghana, had to go to court to seek further interpretation and clarification?
Well, it still confirms the position we held at the time, and I still hold that position. Oh, this is the law. I mean, no two lawyers will usually agree on the interpretation on a matter, but where almost the overwhelming or the dominant position is one way, then it becomes a bit surprising that other persons who obviously are in the minority will not even see the understanding that the majority or the dominant position which most people hold. So, and I think that especially where it is those who have to comply with it that are rather appearing by their conduct, if not by their deeds or by their words, to make it seem as if the ruling or the decision was ambiguous, and therefore they're using that as a pretense not to comply with the law. But I've always held that there was no ambiguity. I mean, most people have held that position. And therefore, moving forward, it appears to me that if anybody who is supposed to comply with these clear orders still refuse or fail, then for me it becomes what some lawyers will say, a contumacious disrespect for the court and the decisions of the court.
So before I make you go, you know that Electoral Commission has been giving up to June 29. I know you don't work with the Commission, but are you hopeful, looking at the processes the EC has followed through since May 5, that it can comply with this new directive?
Well, I think, yes, that's the appropriate word. We can all hope, and we can all believe that. I think so far Ghanaians have made available to them our sympathy. And I think that any step they take outside the compliance of the Supreme Court ruling this time is really going to lead to most people withdrawing the confidence and the sympathy that they have enjoyed from us all these years. I mean, people will then move beyond mere sympathy. And even those who may not have held the position that the EC are just intentionally refusing to comply with the orders, I think they will also join the camp of those who have held all this time that not that they don't understand, it is about unwillingness to do what the Supreme Court is telling them. And it's also because over the years, with all due respect, it has gone into their head that they are independent, they are supreme, nobody can direct them. Now it has become very clear, if it wasn't to them previously, that to the extent that they are independent, they are still under the law of Ghana. And for me, before I conclude, I think that we should all be grateful to God. Even if He didn't give us anything at all, He's giving us not just an independent judiciary, independent-minded, fearless judges who will give justice where it is due. And I think we should be grateful to God.
Right. Lawyer Yaupo, we're grateful to you for joining us on News at 10. Thank you very much. Lawyer Yaupo is a private legal practitioner. He's also a lecturer at the Central University Faculty of Law. I have been joined in the studio by Abu Ramadan, one of the plaintiffs in this case. I could say the main plaintiff. How are you, sir?
You're very fine.
So Lawyer Yaupo is saying we should be grateful to God that we have an independent judiciary. Maybe we should be grateful to the courage of people like you to still go to court. Are you happy now?
No, as a court, let me greet your viewers. As the court earlier on said, this is not about Abu Ramadan or Evans Nimakon. This is about Ghana. Most importantly, this is about the future of our country. And if the Ghanaian people are satisfied, I'm satisfied 100%.
And now that the Supreme Court has issued clear rulings, 29 June, EC must comply with the new directive that has been given. What is your view on this ruling now?
As Lawyer Pon earlier reiterated, is a ruling to tell everybody that truly the Commission did claim they understood but refused to implement, or they didn't understand and refused to, whichever way it is, a blatant refusal to implement the orders of the court as the court ordered. And the court feels it's time for it to crack the whip and make sure the right thing is done. Because they can't afford to throw the tools in the box to the engineer and say, do what you want. They should help them, they should help tailor the process. And I think it's good for us as a democracy, and considering the tension in the system already. This is good relief, this is enough relief, and I'm sure it will bring back a lot of confidence. Back into the Electoral Commission.
But I remember that in the May 5 ruling, the Electoral Commission to explain what it understood by that ruling. Did it do the same today in court?
In court, should I call it an attempt? You know, the court, first and foremost, we sought to get clarity on the orders they had given and direction. But the court was clear. They didn't say, oh, this is what we meant. But based on the pronouncement of the court, they were clear that we're dealing with health insurance card holders. And we expected their names taken off the register. No other group or no other sect were we looking at. We were dealing with the health insurance card holders, and that's the bottom line. So today in court, it was more or less to say that, yes, the judges understand that, yes, the need for us to clean the register, the need for the commission to do the right thing. So based on that, they wouldn't allow the commission, because their lawyer didn't find it easy today in court. Neither did my lawyer to as well. It was a very tensed atmosphere.
So did the EC's lawyer offer any explanations to the fact that they couldn't implement
the court gave them an opportunity. Because one principal question the court wanted to satisfy itself with was, what process have you put in place to implement the orders of the court on the with regards to the May 5th ruling? What measures have you put in place? What are you doing? And all the explanation they sought to offer didn't seem to take into consideration the May 5th ruling, and the court felt dissatisfied. That's how come the court said, now put in writing what you intend to do and the processes you intend to follow in giving that ruling or giving that order.
Putting into writing, that's pretty strict and binding on the Electoral Commission.
Today a friend of mine said, that's like writing myself. And I say in school, they write myself. When you already know yourself already, your teacher says rewrite it. It's the same thing, because the court wants to satisfy itself that the Electoral Commission really is going to carry out the orders. They will carry out the orders, because when they put in writing, the court is satisfied. The court is going to make an order or a pronouncement on that processes they have suggested. Should the court be satisfied with it, it becomes an order of the court, so they'll be bound to...
You think we're going to finish this before the elections?
I'm certain. The judges are serious. Even for them to sit on this matter on Martyrs' Day, which is a very significant day for them, and a holiday for them, I think the judges, they are also worried about time, because they keep repeating, 5 months to an election, 5 months to election. We would resolve this matter before the election.
Right, Abu Ramadan.
But I'm hoping we don't vote on November 7th, if this issue is supposed to drag. Because what I'm hearing now, the information I'm gathering now from my sources, I'll wait. Let's meet in court and let's go through the documents.
Right, Abu Ramadan, we're grateful for your time. Thanks very much. Abu Ramadan is one of the plaintiffs which took the Electoral Commission to court, to the Supreme Court, and he has secured a favorable ruling with the Supreme Court ordering the Electoral Commission to provide a list of all those who put their names on the voters register using the National Health Insurance Card. My name is Stephen Anti.